Welcome back. Yes, that is what we will be talking about next on Sunrise Daily. We've got Dr. Wale Babalakin, OFR, Senior Advocate of Nigeria and Pro-Chancellor of the University of Lagos, joining us from our studios in Abuja. Good morning, and thank you for joining us today. Well, as you heard in that opening, track now, just talking about the decision, the impression that not just Senate, but different unions in the University of Lagos, they have all met and they say they do not agree with that decision, the action that has been taken about the removal of the Vice Chancellor. To them, this is tantamount to putting something on nothing.
Thank you very much. I'm very happy to be here this morning and to clarify some of the issues that have come to light. First, let me repeat that the Council complied with due process in the removal of Professor Tony Ogundipe. I've heard a lot of comments in all media, and these comments ignore a fundamental fact. Ogundipe has not denied any wrongdoing. He has not said that he did not spend 120 million renovating the residence of himself and two of his cronies without mentioning it to anybody. It was discovered. It was not mentioned. It was not presented, and there was no approval. That is patent illegality, and he has not denied it. Ogundipe has not denied that he created something very new in the university, the concept of security votes, or he continued it. I don't know when it started. But he pays security votes, which is money that requires no account in a university. He has not denied it. Ogundipe has not denied that he forged documents in trying to present a candidate for Director of Works. He was chairman of the committee, and he was told to collate results. When he collated results, second became first, first became second. He never denied it. He actually, on the floor of council, and it's in the minutes, did not have any comments about it. Ogundipe has not, till today, been able to present a proper account of the university. 3 sets of people have looked at the accounts. None have said that the accounts represent a fair representation of the university's financial position.
All right.
In fact, he concealed it until 2.5 years after council came in, when a Professor Omoleyinwa report found out that he had concealed information and he had presented what is not a budget as a budget. Ogundipe unilaterally sought to appoint a professor into the university. This is the worst scandal in the academia. He sent me a memo that I should approve that the librarian become a professor. I'm familiar with university system. You just don't become a professor. You must go through the process, and then it comes to council for confirmation.
Dr. Babalakin
did not go through any process.
All right, let me ask you this. We'll hear you quite all right, but at an emergency meeting which was held on Thursday, 13th of August 2020 at 8:30 a.m., the Senate did say that the action that was taken by the council constitutes a violation of Section 3, subsection 8, 9, 10, 11 of the Universities Miscellaneous Provisions Amendment Act of 2003 on the removal of the Vice Chancellor of any federal university of Nigeria. Much as, yes, you say those are the issues, but with due respect, they say at the moment that is not the point, but that this is the point wherein this violation occurred.
I will answer you properly, Mr. Chamberlain. You see, you cannot try and becloud the public with unsubstantiated presentation of the law. The law can be interpreted by the courts. If the Senate feels that we have done something that is not consistent with the law, it can go to court, or better still, report to the regulatory authorities, and we will make a presentation on how we complied with the law. But we shouldn't jump. Was the Senate meeting itself valid? I thought Maokwe would be here today. I would have handed her over evidence that the Senate meeting was not a Senate meeting. Let me start. I have the documents here. Ogundipe was removed on the 12th of August. After removal, rightly or wrongly, and I'll come back to rightly or wrongly, after removal, this came out, and I have a copy. Sir, this is from Mrs. Makinde. Sir, the VC has directed that an emergency meeting of Senate should be held tomorrow at the following notice of emergency meeting. Senate members, the Vice Chancellor and Chairman of Senate has directed that the emergency meeting of Senate holds tomorrow. Now, it is the Vice Chancellor that can call a Senate meeting. He was no longer Vice Chancellor, and yet he called a meeting. I was listening to a program in your fellow channel yesterday, another channel, where a professor of law said Ogundipe had called, when they found out that it was not a valid meeting, said Ogundipe had called the meeting before he was removed. But it's so clear here that he instructed Mrs. Makinde to call a meeting after he was removed. It's clear here. These are the sort of things that we need to present to an independent body like the ministry or a judicial panel or something to show that the narrative being presented to becloud the public is untrue. There was no Senate meeting under the law. Furthermore, I have the standing laws of the Senate here with me, and all this I can make available at the shortest notice. This is the standing law of the Senate. It says very clearly that the registrar shall be the Secretary of Senate. In the absence of the registrar, then there will be an acting registrar. This is what the law says. The registrar was not even invited to this meeting. The registrar did not issue any notice of this meeting. The registrar did not delegate anybody to represent it. So when you call a meeting that the person that called it had no authority to call it, and you also call a meeting that the person who is supposed to be the secretary to record the authentic minutes of the meeting was not there, then you have not had a meeting. You've not had a meeting. So everybody is up in arms that I said what happened there was not a meeting. But it's the truth. It's factual. It was not a meeting of Senate. You now carry such resolutions which are invalid on its face. You now carry it everywhere. You carry it to the presidency. You carry it everywhere. I'm sure when the president looks at it, or the presidency, they will ask, and I will show this document, that at the time he called the meeting, he had been removed. You played the clip of ASUU. Let me tell you something. I have watched ASUU on various occasions.
Okay,
and
but
have just kept quiet because really...
Okay, just a minute. Let me follow up on some of the questions before we get to the ASUU bit. Now, the meeting, from the notice we have, was held at 8:30 a.m. But we understand that the council meeting was 11 or thereabout. So if that happened before the council meeting, wasn't he still the vice chancellor at the time?
No. The meeting of council was on the 12th of August. Meeting of council was on the 12th of August. This meeting was on the 13th.
Because if they are saying that they don't recognize that process upon which you're predicating his removal, hence they can go ahead and have that meeting. To you, that isn't valid.
It's not just invalid, it is against the law. If you read the law, and I'm so unhappy that Moakwe is not here, the law states that after the removal of the vice-chancellor by council, the vice-chancellor has a right to appeal to the visitor. He doesn't have a right to deny his removal. He has a right to appeal to the visitor to look at the issues. And if the visitor finds out that there was something wrong with what was done, or in infraction, the visitor can decide, one, I want to get more facts. Please, Ogudipe is here, the council is here, let's look at it. But it's not for you to sit in judgment over yourself when the act states clearly that you can't do so. Actually, the actions of Ogundipe post-removal deprives him of a lot of local standby. Because if you are complaining of due process, you must yourself follow due process. The act says, after your removal, whether rightly or wrongly, you can appeal to the visitor. You don't appeal to the visitor. You declare that you have not been removed because of your own interpretation of the laws. You declare it. In sane environments, he is deemed to have resigned the minute he did that because he is confronting the law that appointed him. Secondly, we get a notice from his lawyer that he is going to court. You can't sit down in the university while you are still in the university, while you are still collecting remuneration in the university, while you are still operating in the university, and decide you are going to court to challenge your employer while on your seat. These are the sort of strange things that happens that I am concerned that my friends in the media are not interrogating these questions. When I held a press conference in Lagos it was on Friday, there were over 30 journalists there. I really enjoyed their company. Then I said to them, has anybody read the act here? Everybody said they have not read the act. So really, we are building narratives on narratives. I am not giving to that. I'm a legal practitioner. I'm giving to presenting facts, issues, evidence. And if there is a dispute, follow the dispute resolution process. Not believe that everybody from one corner or the other can then comment about it.
Just this one, let's go back.
The Senate.
Okay, I wanted to take you back to the act that you began with the other time. Just one moment, Doctor. Section 3, sub 8 says the Vice-Chancellor may be removed from office by the Governing Council on grounds of gross misconduct or inability to discharge the functions of his office as a result of infirmity of the body or mind at the initiative of the Council, Senate, or the congregation after due process. Sub 9 says, when the proposal for the removal of the Vice-Chancellor is made, the Council shall constitute a joint committee of Council and Senate consisting of 3 members of the Council and 2 members of the Senate. Was this process followed?
The process was followed. It just takes you understanding the laws thoroughly. Go to the earlier section where it talks about appointment of vice chancellors. Go there. Go there. Do you have it with you?
Yes, I have it with me, but you'll have to tell me which particular section you want me to read.
Well, I will come back to it because I have my laptop here, but I don't want to lose my train of thought. I will come back to it. I'll check it maybe during a break here. I will come back. We followed due process completely.
Just one moment. The challenge is the contention that a number of people have is that the council took this action without recourse to the Senate. That's just the only thing we wanted to clear.
You see, there are at least some divergent opinions on that. But in the opinion of the council, due process was followed. Ogudipe was given a fair hearing. He responded in writing to all the allegations. His response was admission of what he had done and sending emissaries to beg that, well, okay, there's an infraction and let's put it behind us. Not only that, at the council meeting, when this issue was discussed, he spoke for 1 hour in his defense. You see, fair hearing is being given an opportunity to defend yourself. Fair hearing is being given an opportunity to defend yourself. And we shouldn't start comparing situations that are not the same. If you admit that you are a thief, what is the issue? If you admit that you took money, if you admit that you forged documents, if you admit that you tried to appoint a professor without process, if you admit that all the money you spent, you had no approval, then what is the issue? If you said no to all this, I'm not a thief, you are lying. I didn't take this thing. It's wrong of you to say so. I didn't do this. Then there is a contentious issue. We have to distinguish between an admission and a contentious issue. We have to distinguish it. And we shouldn't becloud what we're trying to do with some procedural issues that don't have any backing. The opinion that has been expressed by some people, there are an equal number of people who have expressed the opinion to the contrary. Now, but the council that is given the role of doing this has done this. Ogudipe has a redress, and that is redress is to write to the visitor, and that is the due process. A man claiming that there is no due process in his removal, who does not follow due process, has no audience. You must follow due process yourself. It is when you have followed due process yourself that you can now say due process has not been applied to you.
Well,
that's the issue.
Okay, well, because we have the 2003 Universities Miscellaneous Act. So we don't know. Could you read to us the section of the law that you have, the specific reference to the process of removal?
You see, it requires interpretation, and it's not something that can be decided in an audience like this. It requires some interpretation. But I will tell you what we relied on.
Okay.
I'm not getting access to this document.
Okay, well, we do have... Okay, let's just play this short clip for you to see, because these are views also coming through from the University of Lagos. Have a look.
August, the University of Lagos Senate held an emergency meeting attended by about 91 professors. More than that registered, that's signified in the petition that they needed to have that emergency meeting. The issue is, what is the issue? We're here because we want to make it known that the alleged or the purported removal of the Vice Chancellor of the University of Lagos has not followed due process, and therefore is illegal, cannot stand. We are not saying that the council has no right to remove the Vice Chancellor. No. We are saying due process has not been followed. There is a laid-down procedure in the extant laws of the Federal Republic of Nigeria, namely the Universities Miscellaneous Provisions Act of 2003. It applies to all federal universities, and it provides for removal of a Vice Chancellor. If there is a need to remove a Vice Chancellor on the basis of misconduct, the procedure is that there should be a joint committee of Council and Senate. This has not been done in this case, and so we're saying it cannot stand. Rule of law has been trampled on the ground. Please, let's note it. We are not saying a Vice Chancellor has or has not committed any offense. So banding allegations or whatever here or there is begging the issue. The issue is, if you say they have done something wrong, then follow due process. And if it's found guilty, so be it. But without due process, it cannot stand. And this council has trampled on due process, and therefore Senate said they have lost confidence in the council. First of all, they affirmed their confidence in the substantive Vice Chancellor, Professor Oluwatoyin Ogundipe, and the loss of confidence they have in the present Chancellor.
Well, Dr. Babalakin, those views, I mean, do they resonate or agree with the provisions of the Act which you relied upon to remove him?
Those are the personal views of Professor Agomo. They are not the views of the Senate, because there was no Senate meeting. Those are the personal views of Professor Agomo. They are not the views of the Senate. The Pro-Chancellor cannot be responding to the personal views of everybody. I've just demonstrated to you that the person that called the Senate meeting had by law been removed. And the option he had was to appeal to the visitor about his removal. And I believe that the visitor will call the two parties and say, present your matter. But he has been removed. I can't respond to Professor Agomo's personal views. I must continue to respond as representing counsel to the views of the Senate. There was no Senate meeting. Responding to these views will put me in a position where I am joining the decay we are trying to correct. The decay we are trying to correct in the university is that the place is not being run according to law. So somebody decides to do something according to law, runs to the villa, and I should now respond to that. I think that's not consistent with law. Thank you.
All right, Doctor. We'll go to break to enable you, as you requested, time to search out those clauses which you referred. So we'll go to break, and we'll be back in just a moment. Please stay with us. Welcome back to Sunrise Daily. Well, have been talking about the Vice Chancellorship position in the University of Lagos, and we've been speaking with Dr. Wale Babalakin, SAN, Pro-Chancellor, University of Lagos. Well, sir, the Act that we've got, let me just go through the 2003 version, if we could put that on the screen. This says, Section 8, the Vice Chancellor may be removed from office by the Governing Council on grounds of gross misconduct or inability to discharge the functions of his office as a result of infirmity of the body or mind at the initiative of the council, senate, or congregation after due process. Then 9 reads, when the proposal for the removal of the Vice Chancellor is made, the council shall constitute a joint committee of council and senate consisting of, it goes on to list it, which is 1, 2, and it goes on. So could you read to us then, concerning the process of removal, the relevant sections that you relied upon?
Okay, now I'm back with you. You see, you are trying to drag me into interpreting statutes, which at this stage can only be interpreted by a body that has the capacity to do that impartially. But I will just highlight one particular thing for you. Go to the, where it says the Vice Chancellor of a university. Go there.
Read the one you've got.
In B2, it says the university shall constitute a search team consisting of a member of the council who is not a member of Senate as chairman. 2 members of the Senate who are not members of council, one of which shall be a professor. Is that clear?
Well, listening, sir.
Is that clear?
Could you shed some light on that?
Yeah. Go to, no, I'm just want you to compare that clause to the clause you are reading.
Yeah.
I want you to compare what I've just read to the clause I'm about to read to you. Constitute a search team consisting of a member of council who is not a member of Senate as chairman, 2 members of Senate who are not members of council, one who shall be a professor. Is that clear?
Well, what we have says 9.2, 2 members of the Senate, provided that where the ground for removal is infirmity of the body or mind, the council shall seek appropriate medical option.
No, I'm not talking about removal now.
Which section are you referring to?
I'm talking of appointment.
No, I was asking about the removal of the Vice Chancellor, sections 8
You have to
8
compare,
and 9.
which is why I prefaced it for you that this is not a forum for interpreting statutes. And I'm not trying to show you the difference in provision between appointment and removal. That's what I'm trying to show to you. And before you can see that difference, you must read appointments. Do you have appointment clause 3?
Well, so you're saying we have to go to
clause
13
3B,
before we come to 8?
Yes.
Okay.
Yes. You have to interpret a statute as a whole. You don't interpret a statute disjointedly. You must have a community reading of statute to extract the intention of the legislature, which is why the best forum for this is an independent panel to look at it and see whether we complied, not on television. But I will just show you one highlight that you should go and think about. And then you will see the difference in the laws. Go to section 3.
Yes, well, section 3, please go ahead, sir. It talks about, yes, it is. It talks about the appointment of a vice chancellor. Sub 1 says there shall be a vice chancellor of a university, and it goes on and on. The one you are quoting is sub 2.
Yeah, sub 2B.
Please go ahead.
Sub 2B. Are you there?
Yes, please go ahead, sir.
Constitute a search team consisting of a member of council who is not a member of Senate as chairman. 2 members of Senate who are not members of council, one of whom shall be a professor. Have you seen that?
Yes, please go ahead, sir.
Now go to removal. Nine. Where the proposal for the removal of the vice chancellor is made, the council can constitute a joint committee of council and senate consisting of 3 members of council, one of whom shall be chairman of the committee. 2 members of senate, provided that where the ground of removal is infirmity. It did not say in this provision that 2 members of senate who are not members of council. It did not say so. So the members of Senate in this section can be members of council. And it's a rule of interpretation that the legislature does not waste its words. If it said in the earlier section that you require the member of Senate to be a member of council, and it comes to the latter one and be silent, that means a member of council can be a member of that committee. I can't go further than that to let you know that there is a major difference between appointment and removal. And that major difference is what has been interpreted correctly by this council and has been lost to a lot of people. Thank you.
But then you also, as you said, it is subject to interpretation, because some others might have quoted and said that, look, it's probably difficult, if not impossible, for the law to have said in 9.2 that two members of the Senate, provided that where the ground for removal is infirmity, they couldn't have removed that latter phrase and put it elsewhere. But then you also have referenced the fact that there's been another appointment of an acting vice-chancellor. Would you say, against the background of that law also, sub 13, would you say that the appointment or the recommendation of an acting VC is in tandem with the law, going by this one on the screen, that the vice-chancellor shall appoint an acting vice-chancellor on recommendation of the Senate?
Thank you. It complied completely. How did it comply? There is no room for vacuum in the administration of a university. There is no room for vacuum. Senate had not met for 5 months or 4, not even in statutory meetings. Not even its statutory role to nominate deputy vice-chancellors to universities. There is a vacancy of deputy vice-chancellor. Senate has not nominated anybody. There is need to have some other members of council that there are roles to be played in their appointments. Senate has not met. As we speak, Senate has not performed its statutory duties. And it was not forced not to perform it. It decided not to perform it because it was on strike. And the strike was voluntary. So are you suggesting that if there is a vacancy and there is no Senate in place, we should not make an appointment temporarily, which we will now seek to ratify by Senate? You see, we have to continue to interpret laws very intelligently. There was no Senate. Let me also add, there was no deputy vice-chancellor. The 2 deputy vice-chancellors, one was indicted in the report, and another one we felt that had been part of this mismanagement. And we said, we won't approve them. But we've not even had time to do some of these things, because you call a council meeting and ASUU says that it's going to hold a rally at the venue of your council meeting. ASUU is going to hold a rally. We hold our council meetings in the council chambers. ASUU gives a notice that is going to hold a rally at the foyer of the council. And the university authorities do not make a statement about it. University authorities acquiesce in this use of violence or threatened use of violence to prevent the constitutional role of council. And the same authorities is now saying that, oh, you should have come to the Senate that was not in session. Which is why I tell you that this process requires a community reading of all the sections. It requires knowing the facts, and it requires applying intellect. You brought ASUU in as commenting on this issue, and I was going to answer. ASUU every time we have said in the last few months, issued a notice that we are going to hold a council meeting, ASUU immediately issues his own notice saying that he's going to hold a rally on that day. The first day we did not hold the meeting, it held a rally. It held a rally in a university where the Vice Chancellor had said there should be no gathering of people because of COVID-19. Yet, he ignored this and allowed ASUU to have a gathering. He was complicit in allowing ASUU to have a gathering to prevent the council from meeting. Then the next stage, we wanted to come again. ASUU issues another notice. At no stage did the Vice Chancellor, as the Chief Security Officer of the university, tell ASUU that you cannot. That I am in charge of this university, there must be peace. You are on strike anyway. Why is it that this is the only issue that you come out of strike to play a part? Then ASUU issues a memorandum that Babalakin has been declared persona non grata. I have never responded to it because it's too laughable. It's too laughable. Section 41 of the Nigerian Constitution says that you cannot deprive anybody of freedom of movement. You cannot tell me that I cannot come to a public place. The university is a public place. Because I was asked by some friends, why don't you respond to ASUU? I said, how do you respond to something like that that is clearly unconstitutional? Then, I'm a lawyer. So the first thing, I go into the ASUU Act, which I have before me, which I was going to leave to Maokwe. The ASUU Act, which I have before me, says clearly that the objective of ASUU is Chapter 1, Section A, Intellectual Rights and Freedoms. Right to education and participation to intellectual activities. Right to civil, political, and economic rights. Freedom from protection, harassment, and intimidation. Freedom of movement. Now, how do you respond to a union that violates its own constitution? If you respond to such a union, then you are giving credence to illegality. The state of the University of Lagos is unthinkable. If the EFCC and ICPC should move there, they'll have a field day. I gave some ideas. Yes?
Those documents that you refer to, they will have members of staff there who will graciously receive them from you so that we can equally go through all of them.
Yeah, the Constitution and Code of Practice of the ASUU. It's there.
All right.
So an institution that says it's policy.
Okay.
No. I have to let you know.
Yeah, I get your point, but let me just read out this to you. Now, from your explanation, there was no Senate in the involvement in all of these processes, but one wonders, I mean, you knew that there was no Senate at the time. So does the fact that there was no Senate invalidate Section 13, which says that where there is a vacancy, there has to be a recommendation of the Senate before that is carried out?
You see, the first statement I made to you is that the university must run. The university must run. That's the first statement. Second statement I made is that the Senate not being in session was because the Senate voluntarily decided not to be in session. So the Senate frustrated the operation of its body itself. It wasn't frustrated by the federal government. It wasn't frustrated by the council. The Senate frustrated it itself. And in law, nobody can rely on a self-induced frustration. Is it that if we now caught somebody going to looting the university, and then you say, we have to wait for Senate to come back before we cure the heel? There is no court that will interpret that way. It would have been a different thing if the council had incapacitated the Senate. But we didn't. The Senate incapacitated itself and placed itself in a position where it could not play its role. And even when it attempted to play it, it played it unlawfully. The person who tried to call on Senate was no longer in a capacity to do it. The registrar, who can give us the minutes of the meeting, who can tell us what happened, was not there. The law says he can appoint an acting registrar. No acting registrar was appointed. So you now say that a body, the council, which is a body of law, should now respect such a decision. No. You see, we shouldn't forget the primary objective. Primary objective is that it is embarrassing that in Nigeria, our children are going to school in Ghana, in Sudan, in all these places, because we don't have a good calendar. Because the quality of education is not the quality of education when I went to school. So we came to UNILAG with one objective. We will turn it around. All the 5 representatives of government, all, are unanimous on this issue. If you see anybody backing Ogundipe on any of this issue, that person is complicit in the management of the institution. And I will present it to a panel.
Okay, at that point,
can we just... There is nobody backing Ogundipe.
My apologies. Let's just listen to this so that I can take up the next point on this same appointment.
Again, we also heard over the social media that an acting vice chancellor had been appointed. That flies in the face of justice. That's not what the law provides. It provides that if there's a vacancy and there's need to appoint an acting vice chancellor, that council has a right to do so on the recommendation of Senate. This has not been done. So we're not dealing with the banana republic. So we can't wake up and just rewrite the rules and think that things will stand that way. So if we keep quiet, today is University of Lagos. Tomorrow will be another university. So it's not about University of Lagos alone. It's about what the federal government, what government prides itself in, that's rule of law, doing things the right way. And when things are not going the right way, being able to speak up and speak out and say, this is not the right way, it can't stand. So the Senate of University of Lagos is saying, this purported decision cannot stand. Let due process be followed.
How will the university respect the decision of the council, which from that perspective did not follow the rules because there wasn't any Senate, as you said, at the time?
But I have explained to you, there was no Senate meeting. There was none. Everything Professor Agomo is saying is a personal opinion. There was no Senate meeting because Professor Ogundipe, who called the Senate meeting, was no longer Vice Chancellor. There was no Senate meeting because the authentic minutes of the Senate that we can rely on, which should be written by the registrar, there was no registrar at the meeting.
Not relying on whether or not there was a Senate meeting now. I'm just with direct reference to the procedure for the appointment of a vice chancellor. If there wasn't any Senate at that point, does that mean that that part of the law is invalid because it is still what the law provides?
It is not invalid, but it cannot operate because there was no Senate. If there were a Senate, we will have referred it to the Senate. The Senate has not met for 4 months voluntarily. They were not hampered by anybody. And they have not even done their statutory obligations to the university. So there was no institution that it could have been referred to. So you have to get that very clear. There was none that we could have referred to. And you realize that there must be no vacuum in the university. And there was no deputy vice chancellor. at that time. So clearly, the university, the council, as custodian of the laws, must do something. And when the Senate resumes, we can seek ratification. And at that stage, the Senate can say, we agree or we don't agree. But quoting Professor Agomo, you are just giving me a personal opinion, which, believe me, it will be wrong to respond to.
Okay, but the thing is, since there was this gap, why couldn't the council wait until there's a Senate and then you carry out the action so that there will be no questions about it? After all, nobody will support corruption where it's proven.
Now, council should wait indefinitely when it does not know when ASUU strike will be called off. ASUU did not say we're going on strike for 1 month. It did not say we're going on strike for 2 months. We will leave the governance of the university with somebody who has admitted on the floor of the House that he is manifestly corrupt and that he has run the university like a personal estate. So if ASUU is on strike for 1 year, we should wait for ASUU. You know, I'm making this statement because I'm a lawyer. I expect Ogudipe to sue me that I said that he has mismanaged the university recklessly, he has abused his office fundamentally, and he has behaved in a manner not consistent with his office. He can sue me. I was so excited when he said he was going to court because I know the consequences. It means he has resigned, apart from being removed. And we will face him in court. But he can't sit down, not complying with due process, ignoring all the processes, and then you now use this as a barometer to judge a council. There was no Senate meeting.
On that,
this is not the first time. Okay. Yes?
My apologies. On the fact that there was no Senate meeting, earlier you said that the Senate meeting couldn't be called because the chairman, the person who is supposed to call that meeting of the Senate has been removed. But that now you're saying that, and as a result, they couldn't hold any meeting. Does that mean that without the Vice Chancellor in place, there can be no Senate? Now, if there is no Senate, from what Chamberlain has also quoted, the law stipulates that there needs to be a reference to the Senate. If there can be no vacuum, couldn't we have a pro tem chairman for the Senate to meet so that all things can be done according to the law?
Well, again, this is speculation. This is your opinion, and I have listened to you many times. You're a brilliant man. But this is the Amendment University of Lagos Senate Standing Orders, which I'll also leave here. It doesn't make provision for what you've just said. If we did that, we'll just be further compounding what the issues are. It doesn't make provision for it. It says clearly the Vice Chancellor can call the meeting, and it says the registrar shall be the secretary, and it also says in the absence of the registrar, there will be an acting registrar. So we can't, you see, the biggest problem we have in all this is that there have been serial violation of the laws in University of Lagos for over many years. And there is now a council that has said we'll put an end to this. And let me remind the world, this council has not attempted to benefit anything from University of Lagos. As pro-chancellor for the last 3 years, I have not collected a sitting allowance. I have not collected a travel allowance. I have not participated in any university project. I have no official car. I have not asked the council for a transport fare. And I have a lodge there. Even when I entertain in my lodge, I bring my entertainment. I have not benefited anything from University of Lagos, and I don't intend to benefit. I'm just here that we must cleanse this rot. I attended University of Lagos 78 to 81. I knew what the university was. There is no relationship. There is no reference to the university I attended. I am also wearing another cap. I'm the chairman of ASUU negotiation. On one hand, ASUU is saying to us, universities are underfunded. Okay, fine. On the other, then I leave ASUU meeting, I come to University of Lagos, I agree that there isn't enough funding in education. But the little we have is being mismanaged in University of Lagos, grossly mismanaged. So what do you say to this? I want to leave a word here let us stop playing narratives on emotions. Let us look at the law. And if we have issues, let us refer to the law to those who are entitled to interpret it. Sitting down as armchair lawyers and trying to interpret serious laws will not go anywhere. I have told you now that all the people protesting, have not followed the law. Senate did not follow the law. ASUU is violating his own constitution. I have a lot of respect for the alumni. A lot of respect. When I pointed out 3 years ago that we have inadvertently appointed an incompetent and a very corrupt man as Vice Chancellor of University of Lagos, we had over 10 meetings with subcommittees, with various meetings. All they said to me, work with him. How do I work with a man that has no integrity? A man that council found out that he lied severally on council. Because of him, we decided to introduce tape recording of council meetings. Tape recording. Everything I have said is tape recorded. On the profile of the convocation, he lied. We played the video and it's still available. We played it to him in the council meeting. He had no defense. Everything he said was true. If we're going to put an end to corruption, we have to start now. Allowing people to hoodwink you about this, he didn't follow process. He was given a chance to respond. He admitted all the wrongdoing. He did all this and is now trying to hide behind some process. He had hearing, we complied with the law, and he's removed. He can go and protest. Thank you.
All right, then we also did reach out to him to see if he could give us his verdict, but we'll see how that plays out. But we do thank you for talking to us today, Dr. Wale Babalakin, OFR, Senior Advocate of Nigeria and Pro-Chancellor, University of Lagos.
Can I put in a word? Please, I wasn't happy that I was alone here. I wish you had brought the other side as well. And then I will play with documents. I will give documents. I've seen so many of these shows. They come one-sided and they tell a lot of lies. I speak with documents. Thank you.
All right. We'll follow up on what you've just said and reach out to him again and see. And then with those documents, which you leave with us in our studios right there, and then we'll follow up on what you've just said. But thank you for talking to us today. We will be back in just a moment. Stay with us.